Hi, everyone. Welcome. Thank you so much for joining us today. Today's event will be recorded and shared with folks who are not able to join us live. I'll first introduce myself before providing a bit of context for this presentation and then passing it off to our wonderful presenters. My name is Jennifer Lee. I use she and they pronouns, and I'm the tech policy lead at the ACLU of Washington, where I work on drafting and advocating for laws that protect people's civil rights and civil liberties in the face of new and game-changing technologies. I'll be facilitating today's presentation and conversation about mobile device forensic tools, or MDFTs, which are cell phone extraction technologies that allow police to extract and examine the contents of your cell phone, including your call logs, contacts, texts, emails, social media, location information, and even your search history in just minutes. We thought that this presentation would be timely because in Seattle, we're currently reviewing Seattle Police Department's use of MDFTs under the Seattle Surveillance Ordinance implementation process. A quick background for folks who aren't familiar with the Seattle Surveillance Ordinance: it's a law that requires any Seattle government agency using a surveillance technology to undergo a public review process and get approval from City Council to use that technology before it's deployed. Currently, we're in the process of retroactively reviewing existing technologies in use. And one of the technologies in this last batch of technologies we are retroactively reviewing is MDFTs, or cell phone and computer extraction tools. As a co-chair of the Community Surveillance Working Group that's tasked with providing recommendations about MDFTs to Seattle City Council, I think it's really important that members of the public and lawmakers are knowledgeable about how this tech works and the impacts it can have on individuals, communities, and our collective rights and liberties. After the presentation, we're going to have a Q&A session, so please feel free to drop questions in there either during the presentation or afterwards. I'm so excited for us to be joined today by Emma Weil and Logan Kepke from Upturn, a nonprofit organization in Washington, D.C. that works to promote equity and justice in the design, governance, and use of digital technology. Emma Weil, who uses they, them pronouns, is a policy analyst at Upturn. Emma's work has included major research into the scope of law enforcement's power to search cell phones, and also technical assistance and advocacy concerning access to social safety net programs, such as work with legal aid to maintain and reinstate people's enrollment in Medicaid and supplemental security income. Emma has a background in computer science and is interested in how technology can both obscure and be the site of political issues. Emma previously interned at the Berkman Klein Center for Internet and Society, researching and writing about the Internet of Things surveillance. Logan Kepke, who uses he and pronouns, is a project director at Upturn. Logan's research broadly focuses on the use of new technologies and their impact on criminal justice and financial justice issues. Recently, Logan has led major research efforts on pretrial risk assessment tools and law enforcement's use of mobile device forensic tools, though his first project at Upturn led Google to ban ads for payday loans. Thank you so much, Emma and Logan. And with that, I'll pass it over to you both.
Great. Okay, so I will share my screen to show the presentation. Right, I assume everyone can see that. Great. Okay, so hello. As Jen introduced us, I'm Emma, this is Logan, and we're here to talk to you about our somewhat recent report, Mass Extraction, which is about how police can extract all the data from your cell phone in minutes. So basically, we spent the past few years researching mobile device forensics tools, or just cell phone search tools. We sent hundreds of public information requests to various police departments across the country, including small local police departments, state police departments, and also from federal agencies. The subject matter of these records requests were records of use for how police use these tools, purchase orders for what they've bought, and any policies they have. We also did a lot of technical research on how the tools actually are able to get information off of your cell phone and any security protocols they can bypass. And we've basically found that these are extremely invasive tools that are a major expansion of police investigatory power. So why do cell phone searches matter? What's on our phones in the first place? So our phones keep track of everywhere we go and everything we do. Some people have called them a window into the soul. They have a lot of information that we're used to seeing on our phones. So tons of photos, videos, texts, call logs, things that are to your friends and family, regular contacts, calendars, and other information like this that's really obvious. But there's also some less obvious information on your phone. So there's online account information, so your email, your social media, and login information for those accounts. And then there's also things like internet browsing and search history, and also location history data that's all stored on your phone. There's also metadata, which is data about data. So for example, when you last opened an app, which apps you use the most frequently, and also sometimes there's location information embedded into files like image files. And this is stuff that we don't always control, that the operating system uses and keeps track of on your phone. So there's tons of information on your phone. It's basically centralized and stored in a way that is really very different from any point in human history where we have not kept this much information on our phones. And in order to extract it, police have tools called mobile device forensic tools that look like this. So they're a combination of software and hardware where the police or investigator will plug your phone into these tools in order to extract the data off of it. This is it working on a tablet, and you can see it's plugged into the phone. And this is sold by a vendor called Cellphone, which is one of the main vendors. So these cell phone search tools, if there is security on your phone, a lot of times these cell phone search tools will allow them to get around passwords and other security if your phone is locked. This doesn't really factor in if you unlock your phone for the police or if you don't have a lock on your phone, but it's in service of being able to copy all of the data off of your phone. They can also narrow what they do by category or by date. So they can do just text, just photos, just calendars or call logs, or they can just extract all of the data off your phone. And once they have this information, they can analyze it extremely efficiently. This is really different from just having your phone physically in their hands and scrolling through things. This is basically being able to search for different keywords on your phone and pull up everything that has that keyword in it immediately. They also can sort the information on your phone by category. So maybe they can see all of the images or all of the text messages on your phone, what date it was created. And they can also use different tools like artificial intelligence tools to sort data by content of the images or even the topic of text conversations, which is implicit information in the data on your phone. So what this looks like, here's a screenshot from the pre-extraction phase of this software. So you can see they're extracting data off of a Samsung Galaxy S10e, and they're checking either the categories of information they want, or they could also just check all of the data. And once they have done the extraction, this is what it would look like on their computer. So it's a little bit blurry, but hopefully you can see on the sidebar, there's different categories. So currently they have the images category up, and they can just scroll through all of the images on your phone in a big thumbnail gallery. But they could also look at just messages, chats, emails, audio messages, etc., or calls and call logs and contacts. So this is a really different view from how most people are used to seeing information on their phone. You can basically see everything out of context in one place, sorted in a very different way, which gives police a lot of power. They can also, as I mentioned, use artificial intelligence tools to categorize the content of things. So in this screenshot, you can see they're categorizing something as a face, which is also can be very powerful. So this is all the capabilities of cell phone search tools. The problem that we're now presented is the fact that most police departments in the United States, or basically all of them, either own or can access these tools. They're available effectively to all police departments. We've seen really small police departments have their own software in-house, and also much larger departments have even more capabilities in-house. And it's a widespread issue. We found that at least 2,000 law enforcement agencies across the US have purchased these products by a range of different vendors, from companies called Celebrate, Grayshift, Magnet Forensics. There's a ton of vendors in this space. And police basically can do unrestricted and invasive cell phone searches for all types of offenses. And most of the time they'll say, oh, we're doing it only in like particularly egregious crimes. But the fact of the matter is they do them in all types of offenses, especially ones where a cell phone is not really even involved. So like petty theft, bar fights, public disputes. We saw even graffiti. You can see I put a box around it there. But there's tons of cases where there's really no relation to the cell phone and police are still able to search it for these types of offenses. And so in Seattle, we have a lot of information. Some specifics are that around the use of warrants and consent searches, which we'll talk a little bit more later in the presentation. But so when police want to search your cell phone, according to the Fourth Amendment, they're supposed to get a warrant. A loophole to this is that they can just ask you for it. And this is a huge problem, as I'll explain, because even though search warrants tend to have restrictions on them, a consent search does not necessarily have the same restrictions. And also consent searches are inherently coercive. So in Seattle, a full third of the cell phone searches we found between the years 2017 and 2019 were based in consent. So there was no warrant involved at all. And of those consent searches, the majority of them had no limitations on the data that police could access from the phone. So these are incredibly coercive situations in which police are getting a ton of information on the phone with no restrictions. And also Seattle Police Department has said that they only use these tools for particularly serious or violent criminal activity, but we found evidence that they've used them for other offenses like violation of pretrial conditions of release or drug charges and gun possession, which might not even have any relation to the phone. So the other thing we're going to talk about is about prosecution of pregnancy outcomes, which is maybe not as much of a problem in Washington state where abortion is legal, but it is really important in the context of mobile device forensics tools because digital evidence can actually make or break abortion prosecution cases. So for background, so far, all of the prosecutions involving abortion or miscarriage have happened in the context of a hospital or emergency services situation where someone has been reported to the police. So there's already a scrutiny of like a physical circumstance involved. But digital evidence can be used in these cases to prove that someone's pregnancy outcome was intentional as opposed to accidental. And this is important because abortion that's done by medication basically looks the same as a miscarriage. And without any sort of like medical proof, prosecution would have nothing besides digital evidence to rely on, or maybe physical evidence of communications. But basically, the digital evidence can play a huge role in these cases. And so far, we've seen prosecutions that have been based on search history and texts and emails. And this is also despite the fact that just searching for something doesn't mean you actually did it. So it can be particularly dangerous to just have this information available to police out of context on your phone. One case where this happened was with Latisse Fisher, who was prosecuted for her pregnancy outcome of a miscarriage. And police were able to get search history from her phone that showed that she had searched about how to induce a miscarriage and had searched information about abortion pills. Latisse Fisher was not actually convicted, but Purvi Patel was convicted. And police found email confirmation of her purchase of abortion pills on her phone and text to her friend about the fact that she was seeking an abortion. And this would not have been possible without this digital evidence from her phone. So this is a really important thing to talk about with mobile device forensic tools because they're basically the reason that these are that this prosecution was successful. So besides just pregnancy outcomes, there's a lot of general problems with cell phone searches. One is, like I said, at no point in human history have we casually stored this much information about ourselves in a centralized and persistent way, and it is now available to the police. So this is really unprecedented access to sensitive information. It's also more likely that people of color and people in poverty are going to be harmed by these tools. They're more likely to face scrutiny from the police and to be sought out and targeted by police, but they're also less likely to have access to secure cell phones because they're more expensive. And as I mentioned with abortion prosecutions, digital evidence could be the only evidence in a case. that's available, which means it has a really high stakes in it, like the Pragya Patel case. And on the other side, digital evidence might actually just be irrelevant to the case, but sought regardless, meaning there's a huge privacy invasion. And sometimes this information could be put in police databases like contacts, especially for gang investigations, and could basically be used in ways that are really unforeseen by the person whose information is being collected. So next we're talking about consent searches specifically, and I'll hand that over to Logan.
Awesome, thanks. So in 2014, the Supreme Court held in Riley v. California that in order to search a cell phone, police must get a search warrant. However, courts have long held that consent searches are an exception to the Fourth Amendment's warrant requirement. But as Emma was mentioning, consent searches, not just of phones, but in general, are inherently coercive due to the power and knowledge imbalances between residents and law enforcement. And there's an enormous disincentive to refuse to give consent, and it is significantly worse for people of color who are under threat from police violence. And the law governing consent searches is especially bad. So when law enforcement obtain consent to search a phone, there are very few limits restricting what they can or cannot do with that data. So to help illustrate the problems of consent searches, I want to talk about two recent cases. The first is a case called Wisconsin v. Birch. So in June 2016, the Green Bay Police Department in Wisconsin, they were investigating a hit and run, a car accident. And they were questioning Mr. Birch, and an officer asked to see certain text messages from Mr. Birch to see if he was there on the night of the incident. Mr. Birch allowed the Green Bay officer to take his phone to download the messages, and he signed a generic consent form for the search. The officer didn't obtain a warrant, but relied instead on the consent search to have a forensic examiner download all the data from Mr. Birch's phone. So the investigation, the hit and run, concluded without linking Mr. Birch to the accident, but the Green Bay Police Department kept a copy of that entire cell phone extraction. 2 months later, in August 2016, a completely separate law enforcement agency, the Brown County Sheriff's Office, learned that the Green Bay Police Department had a copy of Birch's cell phone data and requested that data after he became a suspect in an unrelated homicide investigation. They did not obtain a warrant to access and search the data, and an officer in the Brown County Sheriff's Office actually used that data for internet history and phone location information to build a case against him in the homicide investigation, for which he was later arrested and charged. So there are three problems there. First, the Green Bay Police Department exceeded the authorization of Mr. Birch's consent. He offered consent to just search the text messages, but they extracted data from his entire phone. Second, they kept the full extraction for months after the original investigation was closed, right? It was June 2016 was the hit and run. August 2016 is when a separate law enforcement agency comes asking for the data. And the third problem here is that the Brown County Sheriff's Office, the separate legal law enforcement agency, didn't get a warrant. They just asked the Green Bay Police Department for the extraction. Unfortunately, the Wisconsin Supreme Court said that there's no problem with any of these three factors, holding that the cell phone evidence obtained from a consent search in one jurisdiction can be shared with other law enforcement agencies pursuing completely unrelated investigations without needing new legal authorization. Another case that happened more recently is State v. Baugh, and it illustrates how perilous it is to really try and limit a consent search if you're really trying to. So in this case, Baugh was taken in for questioning by the Prince George's County Police Department in Maryland in connection with a recent murder. And after hours of investigation regarding their whereabouts, Baugh asked highly specific questions of what the detectives will look at if he consents to a search of his cell phone. And so these images are from transcripts of the interrogation between detectives and Baugh. So you can see that Baugh's asking, so you're just going to go through my call log, that's it, right? And the detectives say, the call log, yeah. Baugh then asks for a little contract to that effect, trying to sort of concretize that agreement. Ultimately, after constant back and forth for hours, making sure detectives will only look at his call log, Baugh finally signs a consent search form. And after signing, Baugh then clarifies what's about to happen, and a detective says, same thing we just talked about doesn't change. You might see where this is going. the detective did not just look at the phone's call log. Instead, they exceeded the scope of consent and looked at least his Google search history and his text messages. How do we know that? That's because they used that information later to get a cell phone search warrant. You might be asking yourself here, BA clearly limited his consent to search, right? According to the detectives and the state of Maryland, despite everything, all the verbal limitations that BA was offering, according to their theory of how consent searches work, apparently he did not actually limit his consent. That's because, according to them, he signed the consent search form. A lower level court bought that argument, and the state argued that Bob voluntarily consented to the search of his phone, and he did not include any limits on his cell phone search. So I think this case shows that even if you're really highly specific in trying to detail what law enforcement can or cannot look at and spend hours detailing that and even offer to write up a contract, law enforcement will have you sign a form and then argue that by signing that form, you've actually agreed to a search of your entire phone. The problems with cell phone searches aren't just with consent searches, as Emma was mentioning earlier. Today, search warrants that law enforcement obtain to search cell phones are far broader in scope than is constitutionally permissible. So as part of our public records research and building out our report, we received several hundred search warrants that law enforcement obtained to search cell phones using mobile device forensic tools. Many of these warrants authorize a search of any and all data on a cell phone. Others authorize the search of a laundry list of data, often offering a sort of bulleted list of effectively every piece of data that could be on a cell phone. And others authorized a full extensive download or search to include every piece of data on a phone, right? And although those search warrants vary in their particular language, each one has kind of the same result. They all authorize an unlimited, unrestricted search of a cell phone. So here are some examples. This first example is a warrant that authorizes a search of a cell phone to include, but not limited to, text messages, photos, videos, Facebook messages, Snapchat, no clarification, just Snapchat, phone logs, website search history, etc. So this is a search warrant not limiting things at all, and in fact includes etc. This next warrant authorizes a literal sort of laundry list of basically every piece of data that could plausibly be on a cell phone. This next cell phone search warrant is related to a drug possession case, and it authorizes a search of, quote, web pages / history used to prepare for or hide participation in the offense. And this final warrant, it doesn't specifically state what should be searched for, but it just says that data from the cell phone would provide, quote, further evidence of the nature of the suspected controlled substance exchange observed by police. Notably, on these 4 examples, which are pretty representative of the hundreds we've seen, there's no clear limit on the date or time frame of evidence sought in any of the warrants, nor is there a limit on the kind of digital data that can be searched or how that data may be related to specific criminal activity. In other words, Emma and I would say that these cell phone search warrants authorize an unlimited, unrestricted search, and as a result, should not meet the 4th Amendment's particularity requirement. So what can be done? We believe that mobile device forensic tools are simply too powerful in the hands of law enforcement and should not be used. But recognizing that mobile device forensic tools are already in widespread use across the country, we have a couple preliminary recommendations that we believe can, in the short term, reduce the use and harm of mobile device forensic tools in Seattle. So the first recommendation is to ban the use of consent searches of mobile devices. There are 3 reasons to do so that I hope are clear based off what we said before. The first is that the doctrine underlying consent searches is a basic legal fiction. Second is that someone consenting to a search of their phone really has no clue what's about to happen with their phone. And third, and finally, law enforcement can almost do anything with that data extracted from the cell phone after someone consents. There are a couple other recommendations we have that in conjunction, I think, are somewhat powerful in the short term. So one is requiring easy to understand audit logs. So in order to give public defenders and judges a better chance at suppressing overseas information from cell phones, mobile device forensic tools should have audit logs that actually track how law enforcement interact with the software, especially at the analysis stage. That won't provide any sort of systematic accountability or transparency, but on a case-by-case basis in which law enforcement are using cell phone data, this will help provide defense that maybe certain data is outside the scope of a warrant and should be suppressed. The next recommendation for folks in Seattle is that robust data deletion and sealing requirements should be enacted. So we think that law enforcement agencies should be required to delete any extracted cell phone data that's not related to the objective of the warrant, except for data that might be exculpatory. So data that's relevant should be sealed at the conclusion of the case and made inaccessible for any case that does not ultimately result in a conviction or is dismissed. And we hope that will that sort of recommendation will limit law enforcement's ability to incorporate data extracted from a cell phone into internal databases like so-called gang databases or predictive policing tools or other intelligence databases. And our final recommendation is requiring clear public logging of law enforcement use. So we believe that law enforcement agencies should be required to publicly log their usage of mobile device forensic tools. So this would include things like, how many phones were actually searched by a law enforcement agency, whether those searches were by consent, hopefully not because consent searches have been banned, what type of offenses have been investigated, and whether the search was successful. The hope is that with that kind of public record, there will be a clear narrative around how law enforcement actually use these tools, allowing local advocates to do stronger policy and advocacy in response to how law enforcement is using these tools. And with that, I'll turn it over to any questions that you all have. Thanks.
Thank you so much, Logan and Emma. This was such an insightful presentation, and yeah, just really grateful for all the work you did researching at police use of MDFTs across the entire country. We have a few questions in the Q&A, and I encourage folks to drop your questions in there. But I first, because you just talked about the problems with consent searches, I wanted to ask if there are any data or studies describing the role and prevalence of consent searches, like who consents under what circumstances, and if so, could you share what they show?
Yeah, so 3 things here. So there's one really on-point study specifically. It's a lab study designed to examine the psychology of consent searches, and I think it really highlights the reliance as a legal doctrine matter on relying on the so-called quote reasonable person quote to adjudicate when consent searches are reasonable. So participants were basically brought into a lab and presented with a highly invasive request, and that's to allow the lab experimenter unsupervised access to their unlocked smartphone. Surprisingly, more than 97% of participants handed over their phone to be searched when they were requested, even though a separate group of people who were observers said only about 14.1% would probably hand over their phone. And so that study, I think, reveals sort of this systematic bias where neutral parties think that people will view consent as much more voluntary and refusal to be much easier than actors actually experience it to be, given that 97% of people handed over their phone. The second piece of data we have is just from other law enforcement agencies across the United States. So as Emma mentioned, we saw in Seattle with the Seattle Police Department, roughly a third of cell phone searches were pursuant to consent. In other jurisdictions, we've seen in Harris County, Texas, so that's where Houston is, more than half of cell phone searches were pursuant to consent. And in Denver, Colorado, over half of phones extracted were consent searches as well. The final thing is data that recently came out from California's, I want to get the acronym right, the Racial and Identity Profiling Advisory Board. And they had sort of a large scale study looking at stops in California, finding that 95% of individuals consent to a search when asked by an officer, and that people of color are especially unlikely to feel free to refuse consent and are simultaneously also asked for consent at a significantly higher level compared to white individuals who are stopped. So I think those are sort of the 3 pieces of very specific data we have on consent searches.
Thank you so much for that detailed answer. That's super helpful. We have a number of questions in the chat. So I'd first like to ask a couple of similar questions. So a few folks asked, can these tools extract browser history from, quote unquote, private browsing sessions? And could they extract messages from apps like Signal that use end-to-end encryption? And a similar question to that was, are there any apps or phone security programs that can protect data on your phone from police searches?
Right, yeah, so these are great questions. So in terms of what police can get, the question is mostly about what is actually stored on the phone. So if the private browsing session leaves metadata, then that could be available. If it doesn't, then it's not on there to extract. I would expect that a private browsing session, like it says, would not store important information, but it might be something worth looking into to see like what other information they store that's not the actual URLs you're visiting. In terms of Signal, Signal, I think, stores your messages in a way that's like a little bit more difficult for these extraction tools to get. But if it is on your device, it is sitting there waiting for police, basically, if they have physical access to your device. And this is different from, so this is the difference between data at rest on your phone and data that is elsewhere or being transmitted. This is all about, so I think this kind of leads into the wireless question, but basically it's about what information is physically on your phone, and that is what police can access. But they can also, if you have accounts logged in, can use the account credentials to get remote information. In terms of different apps and security things, there are definitely more privacy focused apps. And I think there are some apps that like do their own encryption in sort of like another bundle within your phone that needs a separate password. It's not to say that police could not just then guess those passwords, or that there aren't vulnerabilities in those apps that could be exploited by vendors like Celebrate that spend like a lot of time trying to exploit apps. One thing we have found, though, that is good information is that the more modern iPhones actually do have pretty good security when it's like used correctly, which is to say, if you have a strong password on your phone, these tools are basically guessing every single password possible in order to get into your phone when they cannot otherwise just get around that process. iPhones have hardware-backed security, which basically means that all of the decryption of information, so the information on your iPhone is encrypted by default when your phone is locked. So any decryption, so unscrambling of that information, has to happen on the hardware on your phone itself. So they can't make a copy of your phone and then use different software to trial your passwords. It has to be done on your phone. So that means that your phone password can actually, on an iPhone, a modern iPhone, can substantially slow down, if not basically stop and prevent police from getting access to the information, or most of the information on your phone. This gets troubling because some of the information on your phone is actually not encrypted at rest, or not encrypted when your phone is locked. So if you imagine you have like accounts logged in and you get notifications on your phone, depending on your settings, like you might still be able to read the content of those notifications when your phone is locked. So information like that might still be available, but there is some good protection, at least from iPhones, which is troubling. And that's why we're trying to get more systemic solutions to these things, because it shouldn't be up to an individual to like have an iPhone, because that's like a pretty high barrier and they're expensive. But I think that gets at some of these things.
Thanks, Emma. And you already kind of started to elaborate on this, but just to be super clear, we had a couple questions about if you could elaborate on differences between wireless and physical data extractions used by police. Could you clarify how that process works?
Yeah, so basically, in order to use these tools, the police need physical access to your device. Like they need your phone, they need your phone in their hands. There's other more intensive like hacking software that can be deployed remotely. One should not necessarily be worried about that unless you're like actually being targeted by the government, in which case you maybe probably already know a lot more about digital security. But for the majority of people who are not like dealing with like pretty intense threats like that, the main thing is just if police ask for your cell phone and can get physical access to it. And this also means that the information, they can't get information, like they can't like, at least with these tools, they can't like listen in on phone calls or monitor your cell phone activity or usage while they don't have it physically in front of them. And so at least these tools are really for the context of they have asked for a search warrant or consent to search your phone. And yeah, I think that's it.
Thanks for your answer. We have another question from an attendee. If your phone is confiscated during an arrest and is out of your sight, should you be worried about police using these tools without consent or a warrant?
Unfortunately, yes, I would be worried. Police are really notorious for doing things that are against the law. As law enforcement agencies, they can, what's called the good faith exception. A lot of times they can get away with things if it leads to like information being found. Basically, if they show that they were right in the end, a lot of times they get justified in the courts, which is really unfortunate. If it's really hard to tell whether or not something's like happened to your phone, but if they have it for a long time or like it's out of your sight for a while, one should probably be concerned because they can just like go and plug it into their software and extract data.
Thanks again for that answer. So we have a couple questions about the recommendations that you provided at the end. Julie asked, have these recommendations been implemented or partially implemented in other cities? And do you know what has been the impact of these policies?
So one example that we're still trying to figure out the full effects of is that in Michigan, they actually implemented a consent search ban, at least is what people have been saying. The problem is that it basically just says that police need to get a warrant, which is already the law. And consent searches are generally seen as an exception to that. So we're not fully sure how that will really play out. We hope it will be an effective consent search ban. We've also seen consent search bans for specific like populations, so like minors or in the context of traffic stops, I think in California and New Jersey. But our theory is that this mobile device forensics tools shows a particularly egregious like context in which consent searches can happen, but consent searches always have an inherent power dynamic to them that makes them really just inexcusable. So we would like to see consent searches in general banned, and especially ones of cell phones, because there's such an information asymmetry, because people don't know about these tools for the most part, and would have no way of realizing that this is what is going to happen if they consent to a search. Logan, I don't know if you remember any other policy stuff.
Yeah, I would say at a high level, not a lot of places have done policy that would advance the kinds of recommendations we like to see, largely because this is a new kind of investigative technique that has vastly expanded over the past decade. There are a couple of laws that do exist that are related to cell phone extraction, but are not perfectly on point. So there are electronic communications privacy acts in New Mexico and California. The New Mexico one requires that information that's obtained through the execution of a warrant that's unrelated to the objective of the warrant be destroyed within 30 days, which is close to one of our recommendations. We've heard that's not really been followed. In California, I believe that kind of data deletion and sealing is upon like a judge's discretion, which probably doesn't happen all that often. But in terms of a jurisdiction that has implemented all of the recommendations we have together, so banning consent searches, eliminating the plain view exception, which we didn't talk about, but is sort of this highly complicated legal concept, data deletion, audit logs, and public logs of use. We have not seen a single jurisdiction have all of those policies enacted simultaneously. And hopefully we will in the future, but it's sort of more ad hoc, as Emma was mentioning.
Thanks, Logan and Emma. And I also saw a similar question from Alex about examples of legislation from other jurisdictions for recommendations to the City Council, and have we been in touch with the executive about these recommendations? So as I mentioned earlier, we're in the middle of reviewing the MDFT use by SPD, and ACLU of Washington has submitted recommendations via public comment. We also sit on the Community Surveillance Working Group, so we're in the process of reviewing public comments and submitting them for consideration to City Council. And then, but at this moment, we haven't been in touch with the executive, but we hope to be in touch once this process moves forward and we have our recommendations written and submitted. And I know that Upturn has also submitted recommendations. Thank you so much. We have some really, really great questions. Emma, you touch upon this, but Maya asked, what are the security implications of using biometric passwords and logins on your phone for MDFTs?
Yeah, so depending on the phone, this can show differently. For the context of iPhones, because mobile device forensics tools do have a hardware component, meaning they have to actually plug your phone into their computer or tablet or whatever is running the software. With iPhones, at least, the computer needs to be a trusted computer for data to be transmitted, which means that depending on when you last actually unlocked your phone, biometrics might actually not be a pathway into them getting access. Sometimes it needs you to actually retype your password in and won't just allow it based on biometrics. In terms of them doing a manual search, which is sort of just them scrolling through your cell phone information, they could coerce you into using biometrics to unlock it. So that is an issue. In terms of non-Apple phones, there's less security protection at the hardware level in terms of transmitting data. And if you have a fingerprint unlock, it might be an access point for that as well. So there's also different ways. I think iPhone has introduced this, and I think Apple has, Android phones have as well, a sort of panic mode that will, I think also if you restart your phone, usually it requires you to type your passcode in as opposed to using biometrics. So something as simple as turning off your phone if you can before giving police access could actually help in terms of minimizing the amount of data that they can access and minimizing the ways that they could get it, including biometrics.
Another thing to note on that is there's actually an interesting sort of fracturing at a legal level of the Fifth Amendment protections that courts have determined we as people have, dependent upon the kind of protection you use on your phone. So generally speaking, so I'm not going to go through all the different cases, but generally speaking, courts have seen that, courts have ruled that law enforcement can compel production of a biometric, so your face scan or a fingerprint, in order to unlock your phone, whereas a password cannot necessarily be compelled. And this gets to the sort of legal doctrine of providing testimony that's self-incriminating, and whether or not the testimony is actually revealing, quote, the contents of the mind, or if the thing is actually testimonial in nature. So some courts have said that, an alphanumeric password is testimonial in nature. It is revealing the contents of your mind, so you can't be forced to produce that. Whereas some courts have, in our view, wrongly, but nevertheless decided that production of a biometric like your face scanner or fingerprint can be compelled because in various court reasoning, if that item is not testimonial in nature.
Thanks for this great and comprehensive answer. There's a question from Julie. What is the role of big tech companies like Google, Meta, and Apple? Are they able to restrict or lock any of our data to prevent law enforcement from accessing it? Is there a history of these companies working with or against law enforcement in the past?
Yeah, so Unfortunately, a lot of the reason that information is not encrypted in certain contexts is because of like use by these companies, because that's like how they make their advertising money. So there definitely are those forces of the market at work. Other companies like Apple have done like a pretty good job in terms of security and in terms of designing their systems in a way that does not give their own employees access to things. So like I can pass this to Logan to talk more about a pretty high profile case a few years ago about Apple v. FBI, if you would like.
Yeah, I mean, in the sense of there's a high profile case, the San Bernardino shooting, where law enforcement was trying to compel Apple to basically build in a back door such that they could unlock the phone of the San Bernardino shooter, and Apple refused to comply. That created this whole large legal dispute over whether or not large technology companies could be forced to compromise the security of their fundamental architecture in order to obtain evidence from a single phone. And that dispute ultimately got resolved in a different way, where a separate company was able to bypass the security settings on the phone and ultimately unlock it. Ultimately, as a lot of commentators have noted, between companies like an Apple and mobile device forensic tool vendor like a Cellebrite, there's kind of this persistent cat and mouse game where Cellebrite will come up with new features or new ways to access even more data off of a phone from a vendor like Apple, and Apple will try in response to make sure that they are patching any vulnerabilities or making your phone as secure as possible while still making it usable for a day-to-day experience as a user. And they roll out different features all the time. That is probably an unsatisfactory answer as to the role of big technology companies per se, but I think it's a fairly descriptive answer as to what is occurring right now.
Thanks for that great answer. We actually have a question specifically about the cost of these tools. Do you know how much MDFTs generally cost?
Yeah, so for basic software, it's a few $1,000s usually, which is pretty affordable for a small department. A lot of them also can get federal grants from the Justice Department to purchase these tools specifically. So it's like not even a cost factor that the small department has to front on their own. In terms of more intensive versions of the software, there has been a like more recent regime where vendors like Cellebrite will allow you to send the phone to their labs and they will unlock it for you for cases where your software version that you purchase doesn't have like brute force, which is just trying a bunch of combinations in sequence unlocks. And they'll be like, okay, for $1,000, send it to us and we will just work on it and send it back to you. This I think has probably gotten cheaper, and also other vendors. So one prominent vendor is called Grayshift, and they have a device called Gray Key that I think it's $15,000 for some maybe 50, I forget exactly, maybe 300 unlocks, a lot of numbers in here. Some pack of unlocks basically, and then $30,000 for unlimited unlocks. And by unlocks, I mean literally like brute forcing a password on an iPhone. And that was sort of their selling point for a while, was like, we're gonna give you this technology and you can just plug an iPhone in and unlock it. So it ranges a little bit, but a lot of the like basic extraction analysis software is like really affordable to police departments.
Yeah.
And by affordable, I mean like accessible, not affordable in a good way. Like these are obviously really invasive tools that we don't want people to be purchasing.
Yeah, two more extra pieces of information there. So one thing that makes this market, like as Emma was saying, affordable from a law enforcement perspective of spending not a lot of resources, is to buy the physical hardware. That might be an initial outlay of, you know, $10, $12, $15,000. But then every year you only have to pay a license fee of maybe $2,000, $3,000, which in any large police department budget is minuscule compared to the amounts of money they're spending on other things. And on the point of unlocking services also being quite cheap, we actually have pretty specific data from the Seattle Police Department and our public records response that they provided us. So in 2018, Seattle's police department purchased 20 actions, so unlocks for $30,000. And one example is the Seattle PD sending to Celebrate an iPhone 10 with an unknown 6-digit passcode in August 2018. Celebrate received that August 24th, began processing August 28th, and finished processing on September 12th and shipped it back the same day. And that's, a pretty quick turnaround for a service that costs between, $1,000, $2,000, as Emma was saying, gets cheaper the more bulk actions you purchase. And again, that's for these sort of more sophisticated tools. But yeah, it is quite cheap compared to the level of invasiveness that the tools offer.
Thanks for that detailed answer. Vanessa asked, you shared an example of cell phone data shared between local police departments. Could law enforcement also share data with federal agents like DHS, or are there any protections in place to stop that kind of information exchange?
Yeah, I mean, unfortunately, there's a lot of information exchange like in all areas of the country. So like, for example, in DC, which is maybe a little bit more of a specific situation because there's so many federal agencies here. But they, like DC police, for example, shares information pretty readily with like the Virginia Fusion Center and like other state databases and like federal agencies. So there, as far as I know, I mean, actually, Logan, maybe if there's specific laws against this, but there's a lot of different like information or intelligence centers and fusion centers that can just like get this information and sort of have it stuck in these systems that have very little accountability and very little process for removing information, even like incorrect information. So it is like a huge problem. Yeah.
Yeah, I think fundamentally, there are some, local ordinances or state laws that try and prevent, especially entities like ICE, from accessing data from law enforcement agencies. I think while those laws are well-intentioned, I think ultimately they're usually pretty porous, and law enforcement find many ways to work around them. So I think the unfortunate answer here is, even if there are pretty on-point laws, things like Emma was saying, fusion centers are literally constructed for the purposes of information sharing. And it's very difficult from an outside researcher or advocacy perspective to be able to perfectly map the connections of law enforcement A sharing intelligence with law enforcement agencies B, C, and D. But I think it's a pretty fair assumption to say that, if this, the Seattle Police Department extracted cell phone data and wanted to share it with an entity like DHS, I'm unaware of an affirmative law prohibiting them from doing so if they wanted to.
Thanks, Logan. Thanks, Emma. Stan asked a question. If a phone is lost or stolen and ends up in police custody, can they do a search of its contents without a warrant to, quote unquote, find the owner? Are you aware of any situations in which that has happened?
That's a good question. I feel like police departments have like accumulations of unattended to cell phones. So I feel like on one hand, they might actually just not care. I mean, if it's part of an investigation, they probably will do something to it to find the owner because they're like trying to do the investigation. If it's just like in a lost and found, they probably are not going to spend resources toward it because they don't even give people back their own cell phones that are part of investigations. I think a newspaper called The City that's based around New York City did an investigation that showed like most of the cell phones that the NYPD confiscates, they just like don't give back. I don't think they're doing anything with them because they have no incentive to, but if it's part of investigation, then that really changes the incentives. So that's how I would think about that.
Logan, did you want to say something?
Oh, yeah, I think just to add on to that, I think if law enforcement were trying to find the owner of a cell phone or determine who the owner of a cell phone was, and they did not have consent or a search warrant, they'd have to have some sort of justification like exigency in order to, so basically there's some serious likelihood of bodily harm to someone or the owner of the phone. Basically some major events might happen if they can't access the contents of the phones, and relying upon that standard is often abused. by law enforcement agencies. So it definitely could happen. But as Emma was saying, I think more often than not, what we see is law enforcement just retaining several hundred cell phones for years. In DC, there's actually an ongoing lawsuit with the Metropolitan Police Department holding the phones of, it's a class action lawsuit of the MPD holding phones of, dozens of people for years without returning them. And it's unclear why they're not returning them. It's certainly plausible they might, but I think the more realistic explanation, as Emma was saying, is it might just be languishing in a room in a police department office.
Thanks, that's really helpful. We have a question from Michael. Are you aware of ways that the defense can use the data contained on a phone to help exonerate a defendant?
Technically, yeah. I would say one huge red flag that Logan and I both see going off right now is that you should never consent to a search of your phone because you think there's exonerating information on it, because the police will just take everything. You should only give your actual attorney access to information and do that very carefully. You shouldn't just assume that the police will act in good faith and only take the exonerated information off of your phone. But yeah, technically there could, if you say you send a text message to someone to say something and then it's there, that is could be used to help you, but I would say be very careful about it.
Yeah, another thing to mention here is that if you are a defense attorney and there is cell phone evidence that's extracted from a cell phone in your case, there are a couple different ways that evidence could be presented to you as discovery. The worst case scenario is it's presented as a PDF of just literally thousands of pages of all the gigabytes of information that's on your phone, which is an impossible task for anyone. Even if you have a ton of technical expertise of what's on a phone, going through thousands of pages literally printed out to try and figure out what's where and what potentially is exonerative, it just takes a lot of resources and a lot of time that a public defender or criminal justice attorney might not have. There is the option for defense attorneys to get production of these extractions in a file format called UFDR. So that's Universal Forensic Device Reader. That's a file format that can be produced to defense attorneys, where if there's an extraction at issue in your case, you can receive a file of the extraction, as well as the program that can allow you to view that extraction in the exact same format as Emma was describing earlier, with those sort of pictures of or the screenshots of the pictures and the facial recognition, that kind of thing, which is infinitely more usable for an attorney who's trying to figure out what's where on a phone and what might be what might be evidence that supports an alternative theory of who else might have been at issue, or other ways to support a theory that exonerates a client.
Thanks, Logan. And I just want to note we just have a minute left, so I think we have time for one more question. But there have been so many amazing questions in the chat. Emma and Logan, is it okay if folks email you if they have additional questions they'd like to ask? Okay, thank you so much. So the last question, somebody asked, Amazon has Ring, or the Ring. Will cell phones being accessed allow police to go through videos recorded on Ring as well?
Anything that your phone has stored on it can be accessed by mobile device forensics tools. And the other thing is, if your account, so let's say you're logged into an account on your phone, the way that you can actually stay logged into that account is because your phone stores something called an authentication token. These mobile device extraction tools can also extract that token and basically pretend to be you in your login session and log into accounts on your behalf. This is a little bit complicated technically and not necessarily something that is a go-to method. And also, conceivably, they will need a second warrant to do this, though it's unclear how often this happens. So technically, if you are logged into an account on your phone, and it happens to be your Ring account. I've never used Ring, if you can't tell. So I don't actually know. But conceivably they could get to your account and see anything that's stored in there. In terms of whether or not you're asking about a wiretap style thing, this doesn't allow a wiretap or them to like actively record stuff that's on your phone.
Thank you so much for that great answer and this wonderful presentation. It was super informative. As I mentioned in the beginning, it's recorded and we'll be sharing it either online or by email. Please contact Emma and Logan at their email addresses on the screen. And yeah, thank you so much. Really appreciate you taking the time to share the findings in your report. All right. Thanks, everyone.
Thanks.